All right, welcome everybody. Thanks so much for watching this video. My name is Mark Radcliffe. I work with Duality Law and, well, Duality Inc. in general, of which one of our tools is Duality Law. And I have here our CEO, Haroon Hamid. Haroon, how you doing today?
Hey, Mark. Good to see you, sir.
Yeah, it's good to see you too. Today we're going to look at ways that we can use Duality Law to get the best representation for ourselves in legal cases. Haroon, how would you describe what Duality Law does for people?
So Duality Law is a product that's designed to help lawyers, law firms, and self-representing individuals, in particular, obtain the best possible representation for themselves, right? We know that, sometimes legal research is really time-consuming. I mean, there's a vast amount of literature, no matter even what kind of the best tools that you're using. And so what we've done is we've really simplified that process, and we obtain the best regulations, codes, statutes, and case precedents that support your legal position and your legal arguments. And we help tailor those arguments and the correct citations, which are all double checked, so that you can have the best possible representation for your client or for yourself.
Yeah,
right?
Thanks for that.
And we not only do that, we predict the opposing arguments, the counter arguments, and then we rebut them in advance. And at the end of it, we come up with a likelihood of success based on the type of case submission that you're filing, whether it's an answer to the initial charges, in some other pleading, or if it is a motion to dismiss, or it could be a motion after your case is complete. It could be like a motion for judgment non-standing with the verdict, or for a number of other post-trial motions that can help overturn the verdict as well. So
yeah, thank you. When you think about law, you think of like just the literal volume of material, right, that has to be consumed in order to make decisions. Yeah. And that's a real sweet spot for things like large language models and things like that, is being able to like really process that just literal volume of text, right, that has to be read in order to
massive. Yeah, it's a massive data sets that we're pulling.
Yeah. So as an example, Haroon, if you're good with it, I thought we could kind of walk through the interface, imagining that I'm trying to get the best representation for myself. This is what is called the case predictor inside of the tool. And it's literally a form that is going to guide me through the process, right?
Yep.
So,
starting at the top, I know that, Mark and I were looking at this a couple of minutes ago, and we filled in some of the details. But for example, the name of the court, if you don't know it, the name of the court, you can simply click on that question mark right above it, and it'll give you the names of the courts so that you'll know exactly what your summons or whatever your charging document may say. It'll say it on there, so you can look on the document that you've received from the court, or that as a lawyer you may have received it for your client, or clients may have received it for themselves, and you can simply look at the document, fill that in. And then go on to the next prompt. You put in the state, the case number, the name of the judge. That can be very important because we do search by judge name, and try to find cases that this judge has previously adjudicated in the past, and what their behaviors might be, and if that might be able to help influence any of the cases that we cite. It could influence the behavior of the application. And then the name of the defendant. Some of the other information is, not mandatory. So it's not required. The name of the lawyer, the name of the defendant, the address of the defendant. This can be filled in later. You can pick the case type if you're being represented by yourself or by counsel, of course.
And we have both criminal and traffic, right? Like if I switch
criminal and traffic.
So we're going to do a criminal one today.
Yep. And just as a little blurb in here, we'll probably be coming up with torts or civil lawsuits is going to be our next big venture, which I think would be something really interesting. And all this is stuff that, I mean, I don't know if a lot of other people are in the market with this, but I think there's a big need for it.
Yeah. So I'm pulling all of this right off the document that I have, right? So I'm filling all these first ones in. I'm picking my subtype. We're going to start right at the top.
We're going to do murder. We'll stick with one today, but you can do multiple.
And you see that when I selected that charge, it's populated an entire questionnaire that's going to walk me through the process of creating this.
Yes, sir. Let's go with motion to dismiss.
Okay.
We're not going to upload an initial charging document, but we could, if you want to, and that would just create a two-step formula where you would answer some initial questions, and then there would be personalized questions based on your document and the information that's within the document. And you're always free to upload any documents that you have into the system, and it'll take those into consideration.
What kind of documents might those be? Like, what would be examples of those?
Whatever sort of charging documents you may have, like any sort of legal documentation that you might have, any sort of previous pleadings on both sides of the picture. All of that could be taken into consideration as we go along.
Perfect. Okay, so I've got my motion to dismiss. And you probably noticed too, like as I roll over these, it's giving me tips of what these things mean. So you can get a little bit more detail, particularly useful if I'm representing myself.
Right.
And there's the upload document that Haroon just referred to. And now we're filling out the actual event information itself, right?
Exactly. And so we'll do when did the murder occur, like let's say November 23rd or something.
Yeah. And where? And
Annapolis, Maryland.
And Haroon, I'm going to say there might be some misspellings here as we go, so don't judge me if I misspell. And then a lot of these are the beauty of these drop downs too is it helps you give the perfect answer, right? If you're not sure what to type, drop downs are going to really speed up the process.
Let's go with a witness.
Yep.
Let's go with the witness. Let's make this a little tricky. The name of the witness will be John Doe.
Okay.
The relationship of the witness to the victim, neighbor. Sounds great. Did the witness see the accused murder victim? No, because that would be pretty hard to get out of. The witness see the accused engage in a verbal conflict with the victim? We'll say yes.
Okay.
And then you said there was a screaming about a lover's triangle.
And you can see here, like as I'm selecting these different drop downs, it's literally adjusting the form, right, to help me fill it out as well.
Yes, sir. Physical conflict, yes, of course, yeah. Also, there was punches exchanged, and threats of death made on both sides during the fight about the love triangle.
Got it.
Where the witness sees and accused the vicinity, yes. It was seen 1 hour prior in the area. Any conflicts? No. No conflicts. Evidence, the prosecution, fingerprints. Let's go with fingerprints. Not on the murder weapon. Vicinity, yes. Fingerprints are found in the home near the body. The accused have an alibi, yes. He was sleeping at home in bed.
Okay.
Any witnesses? No witnesses.
All right.
Relationship between the accused and the victim. You just say other.
Okay.
Say other.
Others at the bottom. There we go.
Yeah, they're none. Just say neighbor.
Neighbor.
I mean, it could be. This can happen. People fighting over a girl in the neighborhood.
Yeah, this feels very realistic to me.
Feels very realistic.
Yeah.
Is there previous conflict or issue? No.
Okay.
Accused read the rights. Yes. So we read the rights. Evidence collected property to the best of our knowledge. Yes. Yes, but yes. Chain of custody. We'll put yes. Yeah. No legal defense strategy. Alibi. The person says, I was home alone. I was sleeping.
Yeah.
Nothing that we know of that's happened with the prosecuting attorney in the past. So
Yeah, I feel like sit down, think this through, maybe 30 to 45 minutes, like to think it out, or what do you think time wise and sort of
I think
complete?
this might, if a person knows their case, I mean, this could take 10 minutes. I mean,
Okay.
5 to 10 minutes. If they know their case, they know what happened to them, and if the lawyer that they're hopefully sitting with, or whatever,
Right.
the people will know these are basic facts. These are the hard facts that are going to influence the case.
So someone could
There's all kinds of other facts in life, but these are the facts that are going to matter. These are the facts that are going to matter.
Yeah, so someone could be sat with their counsel, right, while they go through this. And I hopefully this is not too obvious to say, but we want these to all be like truthful and real to the events that happen. Right?
A person's gonna have to answer this on if they want a best defense, just tell the truth.
Yeah.
Tell the truth. I mean, obviously you could always pull permutations, and that's a person's choice. But I mean, you can do all the research in the world you want, and that's your own prerogative.
Yeah. Okay, I'm good to process. What do you think?
Yes, sir.
All right. So what's it doing right now?
So right now what it's going to do is it's going to go ahead and look for all the similar cases that have details that are major details that are similar in nature to the current fact pattern, as well as try to prioritize cases that are either in the same jurisdiction or that have been won at the Supreme Court level.
Oh, wow.
Because the way the law works in this country is that there's mandatory case law, and then there's discretionary case law, right? So each court must consider cases and laws and statutes that are pertinent to their jurisdiction because they were adjudicated in that jurisdiction, or those statutes were affected in their jurisdiction, right? Like in their state or whatever. Gotcha. But the only law that goes over all states is like Supreme Court law, right? So so if you're going to be in Oregon, we're going to be looking for Oregon cases and Supreme Court cases. If we're going to be looking in somewhere else, like in Maryland, we're looking at Maryland cases and Supreme Court cases. Because the other cases, they're good, they're helpful, and if we can't find anything else that helps your specific circumstances set, that little data set that you've created, then we may pull other things in, but those will be less prioritized.
Yeah. And I answered my next question, which was how long does it take? It takes about as long as it takes Haroon to describe what it does to generate an entire case document. And we saw it there in real time. So our first item, we'll spin down to the predictor here in just a moment. Our first item, the actual case documentation itself, right, which we can see on the screen. We can also export that to PDF or Word, right? Presumably for submitting to the court.
It's all editable. So you can go in there and type whatever XYZ information you want to in there.
Got it. Okay.
And you can change if it's bold or whatever. It's got a little text edit feature here. So you can do all these different various things and stuff. There are citations available that we put there that can be deleted. But if the user wants to double check a citation, there's links. There's hyperlinks. They can say, oh yeah, this is Anderson versus Liberty Lobby Inc., or whatever.
Right.
And so, whatever it is, these various cases, Jackson versus Virginia or Maryland Rule 504B, I mean, you're going to get all this information in there.
Yeah. So we've got 2 Supreme Court and 1 Maryland here, right? That's been generated as arguments. And then to your point earlier, we've got these anticipated counter arguments, right?
Right.
With the rebuttals.
Relief. One thing that would behoove, I mean, obviously all legal professionals know this, but you do need to have a certificate of service. So at the end of the day, you need to make sure that you have served your responsive pleading or your motion to the opposing counsel, to the court, and everything. So there's a certification on the bottom. Just kind of taking it over there. I mean, you can obviously add whatever information you need to from your document right in this setting, or download it like Mark said, to Word or PDF and edit it there. So
nice. Okay, so we have all our documents, and to your point, Haroon, there's like a process that we need to follow for highest probability of success. We got to hit those deadlines. But then right below the actual documents themselves, we have a justification for the likelihood of success.
Right, exactly. So it'll attribute the incremental likelihood of success based on some baseline number at times. So it'll see what, depending on the circumstances of your case. I mean, with doing nothing, you may have a 10% chance of being acquitted, right?
Right.
So doing nothing, right? But then it'll incrementally add it based on each additional piece of case information, because the way that the law works, is that generally, each side must make its case.
Yeah.
And based on the way that they've made their case, the judge decides their case. The judge isn't, in certain instances, they can just decide for themselves, But in most instances, it's going to be based on the way that the case was argued. And so these kinds of citations and references are very, very important in the way that your argument's constructed.
Yeah. And I know we mentioned this before, but to your point, this is specific to that judge in that court in that state, right? Like that's what that likelihood
as much as possible. Yes, as much as possible.
When we have it, right.
Yeah, exactly. When you have it. I mean, so it's based on whatever we can get a hold of. So
yeah. Okay. Well, we did in this particular one, we looked at felony murder. We'll have other videos available that will look at all the other various ways that we can use it. But Haroon, thanks so much for walking us through this one. And we'll take a look at some others here in the coming weeks. Thanks again.
Thanks, Mark. Appreciate it.